We are here on the defendant's motion for temporary order. I have read both the motion and the response. Ms. Wolfram.
Good morning, Your Honor. I guess off the top, I did shoot Ms. Schultz right over that we're fine with the mutual restraining order, so I will get that over to her. That's certainly fine. I mean, the main crux of it is that the parties continue to unfortunately be sort of almost on the same page, except not. And the main kind of point I would like to ask the court to consider this morning is that Ms. Dreyer is the plaintiff here. So while I understand that she's not ready, there was many months for preparation, and she's taken no steps. And so while, my client continues to support the entire household, that is not only unsustainable because it is based on the parties, particularly Ms. Dreyer's spending habits. But furthermore, he just shouldn't have to continue to support the family indefinitely. We're set for trial, but I think.
All right, guys. Today we're stepping into a courtroom battle that is already turning tense from the very beginning. The husband's attorney wastes no time arguing that her client cannot continue financially supporting the entire household forever, especially while the divorce case keeps dragging forward. What makes this opening powerful is how quickly the conversation shifts from legal procedure into frustration, pressure, and money problems that are clearly boiling beneath the surface.
That at this point, we should have something that locks us in at least until then. So I think preserving the status quo for parenting time seems to not be disagreed. So that would be right off the top. And then, to lock in what we're doing status quo, I think the request for attorney's fees, I understand, but I'd ask the court to reserve that to the trial date. My client has already paid for attorney's fees. So he paid the fees for her first attorney, which she is excused. He's also paid attorney's fees on her behalf for the criminal case. So he's already paid a significant amount of attorney's fees for the parties. So for her to ask for an additional amount for attorney's fees upfront without any, without exchange for anything with regards to movement on the case does not seem appropriate at this stage. Certainly, I'm happy to have Ms. Schultz on, and I hope that she stays because I think having attorneys on is better than the alternative. But to ask for that upfront when we have no movement towards moving the house, which is the main asset, towards liquidation, doesn't. The only things I will address from the response, again, the mutual restraining order should cover it. The $16,000 that was removed from the.
Things start getting even more serious here as the husband's attorney reveals that he allegedly already paid for his wife's previous attorney and even covered legal fees connected to a criminal matter. Then suddenly, a new issue explodes into the hearing, a disputed $16,000 transfer. The court now finds itself balancing accusations of irresponsible spending with claims that the money was never truly missing, creating a moment that feels far more personal than procedural.
Equity is just in a different account. It's not spent or wasted or withdrawn from anything. It can be replaced. It was part of, we anticipated there to be a settlement per one of the mediations. And then when it didn't happen, we just didn't move he didn't move the money back. So it's not anywhere. It can go back. It just needs to be applied into the correct, the best financial decision for the parties. And so that should cover that. And then some of the bigger ticket items that were mentioned and the reply also, I mean, he's having two households. So the Target bill was spent, outfitting a private space for the kids in his apartment because Ms. Dreyer continues to reside in a marital home and he has an apartment. So he had to outfit it with some items for the children, right? And then, Mr. Dreyer has a job where he has to maintain professional appearances, so he had to buy some new clothes. So if we're going to nitpick each and individual, spending habits, again, I'll just remind the court that she's the plaintiff and we need to move this case forward. So we can't be picking apart each other's, spending habits, but rather we can separate financials and move on with the finalization of this. So we'd ask the court to take all that into consideration, give us a temporary order we can move forward with and get us ready for trial.
What's our trial date?
I'm going to say, I don't remember off the top of my head.
I don't either. That's why I'm asking.
Sorry, I should have looked that up. Let's see.
I believe it's May 27th or 28th.
Okay, thank you. So coming up shortly.
Yeah, really, really quickly. 5:28, 2 o'clock.
All right. All right,
Judge, not to interrupt, but May 28th at 2 o'clock is a settlement conference.
Oh, I'm sorry, you're right. It does say settlement
Yeah,
conference.
I didn't think we were scheduled for trial.
We had asked for it to be set for trial. That's why I said that. And I knew some dates had gone on. But yeah, we had asked I asked for it when I appeared at the motion to excuse Amy. I'm sorry,
Okay.
Rademacher,
Okay.
Ms.
All right.
Rademacher. And so, yeah.
All right, well, while we're on that subject, we have everybody here. Ms. Van Miller, could you look and see what we could set for a trial date?
Yes, so the filing date on this is August 8th. So are we looking in July?
I would think so. If not June.
If not June.
Yeah, June, I would think. Give us a little more breathing room time-wise.
And are we looking in person or via Zoom?
This section turns chaotic fast because the discussion moves from spending accusations into complete confusion about the actual trial schedule. One side argues the husband's purchases were necessary for the children and maintaining his professional image, while the court suddenly realizes nobody seems fully certain about the upcoming dates. You can feel the tension building as attorneys interrupt, correct each other, and scramble to lock in a trial before the entire situation slips further out of control.
Either is fine with me. I don't think there's anything particular to this case that would require an in-person appearance. So I'm fine with that if Emily is.
Ms. Schultz?
I agree with that.
Okay, then why don't we Zoom?
Okay, then we could do June 29th, Monday from 9 to noon.
That is open for me. I have a review hearing, but I can probably get it covered.
That works. That's fine with me as well.
Okay, we have a trial date. All right, Ms. Wolfram, did you have anything else you wanted to say? We kind of went off on a tangent there.
No worries. I think I'm all set. I just think, like I said, especially now that we do have a timeline, I do appreciate that, but the parties are operating without any temporary orders. And every time that we think, and I do think that it's possible to come to an agreement, but basically what happens is when we go sort of off the record, I'm just going to be honest with the court, Ms. Dreyer kind of pulls back and then we don't get one and here we are again. So as much as I'd like to say that I think we can, and we can certainly come up with maybe some minute details between us. And I have every confidence that Ms. Schultz will be able to achieve those things for us. But Ms. Dreyer seems unwilling to fully commit to every agreement that we come to. So we really need that direction from the court so we can lock it in, because it creates a chaotic situation when we depart.
And in your response, you asked for this to be referred to the front of the court.
So
I'm not sure that's going to happen.
No, at the time, Your Honor, Ms. Schultz had not been, when I filed it, she had not retained additional counsel. I don't think that we need a friend of the court. I think that that us attorneys can work that out. And frankly, the parenting time and custody is, for the most part, pretty much in agreement. I think, again, there's some, parameters that we could discuss, but with regards to the actual.
Now the emotional side of this divorce starts taking center stage. The husband's attorney accuses the wife of repeatedly backing away from agreements once conversations move off the record, describing the entire situation as chaotic and impossible to finalize. But then the wife's attorney fires back hard, explaining that she spent years out of the workforce raising children and cannot realistically survive on the financial support currently being offered. At this point, the courtroom battle becomes deeply personal.
Schedule, I think there's no need to change that. So I would withdraw that so long as Ms. Schultz remains on the case.
Right, Ms. Schultz?
Thank you. I would agree with that as far as friend of the court goes. I mean, if we're set for trial that quickly, then I don't see a need for that at that time. We can negotiate parameters. The concern here, and I mean, again, I recently entered this case, so I don't know, what has happened before, during, after mediation, as far as the minute details of trying to get an agreement. But the reality here is that Ms. Dreyer has stayed home with the kids for a significant amount of time. She's been out of the workforce. Mr. Dreyer has, earned all of the financial support for the household. And since they've separated, he's expecting her to live on $2,000 a month. And it's not realistic. So while she's attempting to secure employment and alternate income sources, at this point, she's not yet done so. She absolutely needs a contribution to attorney fees. Mr. Dreyer's got almost $36,000 sitting in an account. So it's a little disingenuous for him to then state that you know, he doesn't have the money. It's sitting right there. So she is requesting, you know, child support, spousal support, at least to get her through. And for the time being, we're set for trial here pretty soon. So Mr. Jar is not going to be, you know, we can reassess this at that point based on where Ms. Dryer is at the time. And then you know, in the response, it's really important that Ms. Dryer hasn't decided yet what she wants to do, what she's able to do. What she's trying to do is breathe financially, and before she can make some decisions on what she would like to see happen with the house long term. So those are really the only things that I would add at this point.
I'd like to briefly respond, Your Honor. There's not that 36,000 includes that 16,000 that they're complaining about, right? So that's the problem, is that that's double dipping. So do you want that money spent, or do you want to account for it, right? Like, that's the question. Shoot, there was two things. I'm sorry. Let's see. Oh, and the $2,000 a month is in addition to 100% of her expenses being paid. So my client is still maintaining all the household expenses. So yes,
The financial fight reaches another level here as both sides directly contradict each other in court. The husband's attorney accuses the wife of double-dipping financially, while insisting he still pays nearly every household expense on top of child support. But the biggest moment arrives when the judge finally steps in and addresses restrictions involving third parties around the children. That ruling instantly changes the tone of the case and reveals how serious the court considers the family situation becoming.
It's like $2,400 of child support, but it's in addition to her living expenses, her utilities. He's paying all the bills and paying child support. So, you know, when we're talking about even more money, we're not asking her to survive on $2,000 a month. She's having $2,000 to, you know, support her portion, you know, support the children on her parenting time, but the rest of her household expenses is 100% being paid. So those are just two clarifications.
All right, well, it sounds to me like there is a stipulation between the parties that just continue the status quo for the time being regarding custody and parenting time. I'll grant that portion of the relief requested. And nobody addressed the third, although I read it, the prohibition on third parties.
I would request that the court does put that in place. I mean, certainly without revealing too much, that was, you know, a point of contention for the mediation. So it was like potentially agreed, but then not, and it was some time ago. But with the idea that my client is maintaining the marital home, it, you know, he is struggling with the fact that we're moving a person in while also not deciding whether we should sell the house or not, right? This is becoming really uncomfortable for my client to have to support her lifestyle and her, you know.
Well, without commenting on whether that may be true or not, any of that, I will indicate that the court does routinely, for the best interests of the children, during the pendency of a divorce, prohibit third parties from being introduced to the children, either party,
Indeed.
because they need the stability during that pendency at least. So I will grant that as well. I'm going to deny the request that the plaintiff or that the defendant be given exclusive use of the marital home and that plaintiff vacate at this time. I do think that we have a trial date set and we can deal with it at that point. I will grant leave for defendant to file his counterclaim. I'm just looking at your prayer for relief. Ms. Wolfram, does that deal with all of it?
Yeah, I think so, because we agreed to the mutual restraining order, so that was stipulated.
Okay.
And that was I think that was in their response.
And other than that, I'm going to leave everything else, the financial orders, the same.
The hearing closes with one final decision that neither side can ignore. The judge refuses to remove the wife from the marital home, choosing instead to leave the current financial situation untouched until trial. After all the accusations, disputes, and courtroom tension, the case now heads toward a much bigger showdown later on. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.